Good afternoon, friends. Today I'll be discussing a very vital and a day to day basis required subject in brief on a particular demand of some people, that why not talk on construction. Now, this word construction in these cantonments is very variedly used, and sometimes we do not realize that what are we actually going in for. So, if we call the same construction repair, there is no hesitancy. Ever since the Britishers, all these properties came in existence. From 29th March 1808 GGO, they said if any house which has been reserved for the army officer, for his tenemency or tenancy, he has no restriction to repair his bungalow, to ask for anything from. So, what are we actually going into for the last some 60, 70 years? If you talk of 200 and some years back, we were allowed to repair our bungalows. We were even allowed to construct our bungalows. Now, coming to Rule 6 of 1925, which I had said, now when these lands come under Category 3, so the only duty of the cantonment magistrate is on the building safety. He even doesn't sanction our plan. He would only see to the bylaws of the cantonment. The same thing was enacted in 1908 to House Accommodation Act, or the bill of it, 1898. Any alteration, any repair at the time of leasing the bungalow or the house or the mahal, estate, to the army officer, we shall be allowed to repair and renovate the same. So, what do? Try and read the definition of building in Section 2 of 2006 Act, which says house, outhouse, stables, latrine, shed, hut, or any other roofed structure, whether with masonry bricks or mud or wood, even metal, any other material. It all includes a well in the house, maybe those walls, boundary walls, but it does not include those any tenant or portable temporary shelters. So what do we do to this house? We need to plaster our walls, we need to change the flooring, we need to change the doors or the chockers, because sometimes they are wooden chockers, termite has eaten them up. We need to change the bathrooms to the new fittings and tiles and bathrooms. If we even want to change our roofs, which have been of asbestos or of the old days cuddy, which you call, and sometimes they are even made of those angles with bricks or tiles, to lintel. We want to make a boundary wall. We want to have a new gate on this. All this is subjected to Section 144 of the Cantonment Act 2006, which clearly says we need to repair our buildings in proper habitable, hygienic conditions. The same section speaks of boundary walls, Section 2. So we are permitted to a particular height of 2.5 meters. We can fence it. Under the House Accommodation Act 1922, there was a judgment of the Supreme Court full bench, which very clearly said that we are put under the 7th Schedule, Entry 3, List 1. So the relation between a house owner and a tenant is a very subjective matter, and all the rules and laws, if have to be made, they are subjected to the parliament or the legislation. Nobody other can interfere it. So when there are so clear rules, then why does the cantonment magistrate or the cantonment executive officer today unauthorizes our repairs or construction? Or why does he stop it? Or why does he even go for sealing in the new Act 2006? Friends, we must make sure first that we do not change our plinths, We do not, under the garb of repair, actually reconstruct. So we are actually then fetching problem for ourselves. So all you have to do is write a letter, draft a letter. If you can't do it, I'll do it for you. Attach your plan. None of the sanction plans are lying with the cantonment. Or if you want, you can even be a little smarter. Ask for your building sanction plan. They don't provide it to you, then you write a letter, this is my building, I need to repair it under 144, I'm going ahead. So you just have to inform them and then you can go ahead. The recent SK Bose committee, even received through me on an RTI, has very clearly said in a letter of 5th November 2019 that the permission of repairs, even under the 1995 policy, should be very liberal, and even to the extent of the Pradhan Mantri Swachh Bharat, that bathrooms and kitchens should be allowed to the 10% of the plinth area. So friends, you don't need to get worried. Just draft a letter under section 144, attach your plan, send it to the department and repair your bungalows. So I think with this, the scare of repairing the bungalow would get over, and then you can question the department, where is my original sanction plan of the building, which you term as that this A portion or B portion is unauthorized. I think if any question, you can come back to me, talk to me. I'm always available, what I said. Thank you. Good day.